Ms. Graham.
Thank you. I wonder if we can have on the screen again PS 04984. And we were looking at this just before lunch, and there are 4 pages. I'm interested in page 2 of 4. We looked at this earlier. So this is the email from Billy Little at Perk on the 14th of May 2015 at 7:55 to Keith Hardy, Stuart Wilson, regarding the family press conference. And we looked earlier, the press release, you can see at the bottom of the screen at the moment, dated Wednesday the 13th of May. And the email from Mr. Little says, "Morning, Keith or Stuart. The Perk was made aware of this late yesterday afternoon." So this would be made aware on the 13th of May. John McSporran, then the lead investigator for Perk, spoke to Mr. Anwar late last night. And it would appear that the thrust of this conference will be to criticise the police officer's decision not to provide statements regarding their involvement. And so it's being sent to the police, first of all to Keith Hardy and Stuart Wilson, not because of the press release or the content of the press release itself, but because it would appear that John McSporran spoke to Mr. Anwar, and the thrust of this conference will be to criticise the police officers, criticise their decision not to provide statements regarding their involvement. So it's an email from Perk to the police, which appears to be concerned that the thrust of the conference from the family will be to criticise the officers. And then moving on, if we can move up the screen. Let's move on to page 1. And at the bottom of page 1, you can see, can we go down? I'd like to see further down, please. Yeah, okay, thank you. Move back up, please. So the original message there, I think, which is being forwarded, is from Stuart Wilson to a number of people who are named, including Nicola Shepherd, Gary McEwen, and it was CC to Keith Hardy. They're all police officers, and sent on the 14th of May at 7:59. You will likely already be aware, but for information. So Stuart Wilson appears to have forwarded that on to a number of other officers. And then if we can move up to the email from Gary McEwen. And this is from Gary McEwen to Lucy Adamson. We heard evidence from Gary McEwen on the 30th of August 2023, day 64 of the inquiry, that Lucy Adamson is with the communications department or unit. And Lucy, please see below. I think we need to be in a position to respond to this. I think the best avenue is most likely federation. We need to be quick with this. Will you link in with exec and feds around this? So the concern appears to have come from Mr. McSporran at Perk to the police, with a concern that the police were going to be criticised. And Gary McEwen has then passed that on to Lucy Adamson with communications, saying, I think we need to be in a position to respond to this, we need to be quick with this. And then also to suggest that the best avenue is most likely federation. I'm particularly interested in your views and thoughts on the fact that Perk's lead investigator appears on the face of it to be concerned about potential criticism of the police, and he's sending information about that to Police Scotland, who then pass it on to the Federation. You said before lunch you wouldn't say you had no concerns. I wonder if you can tell me what concerns you do have.
So I hadn't seen this document before today, and I thought a little bit about it over lunch, and I think the situation where I would have had less concern if not any concern would have been something that I think I see in many investigations, which is each organisation has people who are focused on media roles, and that would appear to be who Lucy Adamson here is. And I think the sharing of press release statements ahead of them being public, I would have expected to be done through those roles for that purpose, so that the organisations are aware of what is likely to be said. Having thought about it more over lunch and your explanation of it just there, it does on the face of it appear to me to be concerning that an investigator working with PERC is sharing a concern that police officers will be criticised. Had I known about this at the time, I would have wanted to understand exactly why this had been done, and to consider that before taking any next steps. But it is not the sort of communication I would have expected to see between PERC and the police.
And when you talk about it being concerning, can you help us understand what your concerns are in relation to that?
PERC is charged with carrying out an investigation into what the individual police officers did as part of their restraint of Mr. Bayou that morning. It appears to me that it is not appropriate for PERC to be sharing with Police Scotland any planned or intended communication which seeks to criticise officers in any way. That's not what I would regard as part of PERC's job, which is to carry out an investigation as to what happened that morning. If there is to be any criticism by anyone of what the police did, then it's for the police to deal with that, either because it's brought to them directly or made public. It's not part of PERC's remit, I would have thought, to be sharing such information as part of their investigation and working with the police. I spoke, I think, before lunch about how I imagined there would need to be contact at an appropriate level between PERC and Police Scotland as the investigation is carried out, but I had in mind that that would very much be around the coordination of the investigation and steps that needed to be taken, not necessarily sharing information of this nature.
And against the background of a number of questions I've been asking about Article 2, and one of the obligations being independence, do you have any concerns in relation to independence in light of this communication between PERC and the police?
Well, it's difficult to draw a conclusion based on one email exchange, but it would certainly, as I said, I think, prompt me to ask more questions and understand what exactly was going on here and why this information was being shared in this way and why concerns were being shared. I would have wanted to either assure myself that there were no concerns that would cause any Article 2 difficulties, or that further steps needed to be taken to protect those procedural principles.
Thank you. And I think you say in your statement that it was important to the Crown that the investigation be independent and the PERC investigation be independent.
Yes.
Thank you. Thank you very much. Could we move on then, please, to another document? This is COPFS 02682. And this is a 7-page document. It's a email thread again. COPFS 02682. Here we are. So there's 7 pages. I'm interested in starting at the earlier stages of these emails, which is page 5 of 7. Now, I think you were included as you were CC'd into these emails at the time, but I'll go through them just so we can get some context. So you'll see that this is the first email I'm interested in is from Ian Campbell. Is at Crown Office Communications? And that was sent to the Lord Advocate's Private Secretary, Solicitor General's Private Secretary, and you were CC'd, you'll see, John
Yes.
Logue, as well as Les Brown and Stephen McGowan. David, PERC line against inquiry. I have been contacted this afternoon by PERC who have asked for our views on a proposed line against inquiry. Now, do you understand what that means, proposed line against inquiry?
Yes, that means that PERC anticipates at some point they might be asked about some aspect of their investigation, and so they want to be ready for that by having worked out in advance essentially what the public answer to that question would be.
They hope to issue this if they're asked about recent Crown instructions to investigate other matters in relation to the Sheku death. And to put some context to that, this is the 28th of August 2015, so it's the period after the first PERC report has been received from PERC by the Crown Office, and we've heard from Les Brown in evidence that he was then in the process of going to issue further, more detailed instructions to PERC, which were sent on the 2nd of September. So that's what was happening behind the scenes there. A spokesman for the PERC said, and this is the line that PERC wished to release to the media if an inquiry was received. The Commissioner recently received further direction from the Crown Office in relation to matters surrounding the death of Sheku. Those investigations are now ongoing. Our view is that if this is then the response in the email, our view is that if they issue the above, it will set an expectation of a blow-by-blow account of our individual instructions and correspondence as the investigation progresses. On discussion with Les Brown, who is content, we intend suggesting to that they do not issue the response above, but hold instead to the latter section of their previous line as below. On the 7th of August, the Commissioner delivered an interim report of the investigation's findings, which are now being considered by the Lord Advocate. The Commissioner continues to work closely with the Lord Advocate, including gathering further expert opinion in relation to the cause of death. It would be inappropriate to comment further at this time, and I would be grateful if this could be drawn to the attention of the Lord Advocate. So it's a request from PERC to issue a line if they receive an inquiry, and an alternative is proposed by Les Brown, and that's brought to the attention of the Lord Advocate. And then we could look at page 4 of the PDF, and if we can see at the very bottom of page 4, there's a letter, an email from the Private Secretary of the Lord Advocate on the same date at 15:15 to Ian Campbell in response, and it says the Lord Advocate has confirmed he agrees with the line suggested by Les Brown. So the alternative was agreed by the Lord Advocate. Then if we can move up towards the top of page 4, which is the third email. This is an email sent on the same day, the 28th of August at 16:23, and it's from Ian Campbell to the Private Secretary of the Lord Advocate. PERC have come back to suggest the slight addition in bold below. This seems fine to me, but just wanted to confirm for the record. And then there is essentially what was Les Brown's alternative comment. There's no bold there, but from my reading and comparison, I think the additional words are in the second last paragraph, to investigate complex lines of inquiry. So they were not in the original Les Brown version, but they've been added. So although they're not in bold, I think that's the only difference that I can see. And then if we can look at page 3 of 7, towards the bottom, we see a response from the Private Secretary of the Lord Advocate on the same date at 17:11, and it says, as discussed, I can confirm that the Lord Advocate is content with the amended response below. And then looking up to, if we start at page 2, please, you'll see an email from Ian Campbell. This one is on the Saturday, so August 29th, so the next day at 4:29 in the morning, to the Private Secretary of the Lord Advocate. PERC have today come back on about this, having now received an inquiry from the Sunday Mail. They're looking for guidance by 6 p.m. They state the Sunday Mail have the names of 2 experts looking into cause of death and are being briefed by Amar Anwar that they have only been chosen by the PERC due to the fact they will come up with the conclusion of excited delirium. As well as the statement that was agreed yesterday, PERC wished to provide them a few additional lines as background, not as a direct quote or source, to give a better context. Their suggested wording is as below. The Sunday Mail understands the PERC were asked to compile a list of experts in relation to carry out further investigations into the cause of death of Sheku Bayo. They were then presented to the Crown Office for consideration. The PERC was then instructed on who they should appoint as the appropriate experts to go and carry out those investigations. On discussion with Liam Murphy and Stephen McGowan, we consider that PERC should issue only the line agreed yesterday, to the effect that this is an ongoing investigation and that it would be inappropriate to comment and nothing further. I'd be grateful if this can be brought to the Lord Advocate's attention. And then if we can move on to the next email, which is page 2, and this is Saturday, August 29th at 5 o'clock. Ian, further to your email below, the Lord Advocate has indicated that he would be content for PERC to respond along the following line. And then there's a remark in quotation. PERC take direction from the Crown on who should be instructed to carry out further expert work on establishing the cause of death. The Crown are considering the points made by the family's lawyer on the instruction of the, I assume that's best experts, to do this work, and will issue direction to PERC in due course. Then if we can move on to page 1, and you'll see that this is an email from Ian Campbell on the Sunday the 30th of August to the Lord Advocate and the Private Secretary. For the information of the Lord Advocate, I have just been informed by PERC Comms that they have been instructed to issue the following by Kate Frame. Kate Frame was the Commissioner at the time. It issued this afternoon, just before they informed us about it. And then if we move down, the PERC has issued a statement in relation to the ongoing investigation into the death of Sheku Bayo on 3rd of May 2015. It comes ahead of a meeting between the Commissioner and the Bayo family on Thursday. Responding to claims reported today about the experts asked to further investigate the cause of death, Kate Frame said, and in quotation marks, "It is unfortunate that the family lawyer, Amar Anwar, appears to have interpreted the fact that forensic pathology experts from Outwith Scotland have been instructed as a sign that the PERC has focused its investigation on a particular cause of death for Sheku Bayo. The Commissioner can reassure the family that in fact the opposite is true. As they and Amar Anwar know, the post-mortem conducted in Scotland did not reveal a conclusive cause of death. In order to assist the family in understanding what caused Mr. Bayo's death, the PERC identified a number of expert forensic pathologists to the Crown Office. The Lord Advocate then selected and instructed the Commissioner to approach the chosen experts and seek their opinion on the cause of death. Both are entirely independent, and Dr. Payne James has already said an expert's duty is to be completely independent, irrespective of who is instructing them. Once the experts' opinions are available, they will be passed to the Crown Office, and the PERC would anticipate that, in accordance with standard practice in a serious case such as this, they will take the opportunity to recognise them as witnesses, along with other significant witnesses identified in the PERC report. The Commissioner will reassure the deceased family at her meeting with them on Thursday that further lines of inquiry continue to be explored. She will be happy to receive any additional information that they might have that would assist the investigation. So it would appear in relation to this that Kate Frame, the Commissioner, then issued her own statement that was not forwarded to Crown for comment before it was released to the media. And do you remember these events?
I'm afraid I don't remember the specifics, no.
Right. But it would appear from what we see in this email thread that the quotes and the comments by Kate Frame, the Commissioner, go far beyond what the Lord Advocate had approved.
That's correct.
Now, I think in your inquiry statement you were asked about this. If we could look at question 20 in SBPI 00441. And if we look at 20, you were asked to look at the email chain, 28th to 30th of August, relating to the PERC's media release. And in light of what we've just looked at, and it's sorry, do you have that? It's
Yes,
on
I
the
have
screen
that.
as well.
Yes, thank you.
The Commissioner, Ms Kate Frame, appears to have departed from the direction she was given by the Lord Advocate and released her own statement to the media to directly respond to Mr Anwar's comments in the media. Please provide your comment on this matter and include your view on whether this is a breach of PERC's duties to follow the Lord Advocate's direction. Do you consider this a breach of PERC's duties under the 2006 Act? Please explain your reasoning. And I'd like to go through that question. I'm not entirely sure your answer fully responds, but we can look at your answer at this stage. So this is answer 20 in the statement. I do not recall the circumstances described in this email chain. Section 41A of the 2006 Act provides the Commissioner must comply with any lawful instruction issued by the appropriate prosecutor who issued a direction under Section 33A. This is similar in scope and effect to the authority of prosecutors to issue instructions to officers of Police Scotland. So can I be clear? Do you consider the correspondence in the emails to have been a lawful instruction by or on behalf of the Lord Advocate to PERC in relation to the media statement that was to be released by PERC?
It's not an example of what is commonly understood to be a lawful instruction, because lawful instruction, in my experience, is commonly understood to refer to investigative steps to be taken by the investigative agency. And what I was trying to explain in the answer is that, having said that, in my experience, instructions given by the Crown in relation to communications are treated as if they were an instruction which had lawful effect. So the end result is the same, but I think on the finer detail, I'm not sure that everyone involved necessarily would see it as being a lawful instruction. Some people might see it as being simply a media matter, but in my experience they've always been treated as if they were a lawful instruction. On one view, they are a lawful instruction because the Crown's interest in handling the media inquiries is directed to the conduct of the investigation, and that is the only interest that the Crown has in ensuring that public communications are appropriate. So if I've been less than clear in the answer, I've been trying to explain the background and the complexity to it. My personal view is that I would regard it as a lawful instruction, both in terms of the substance of it and its effect.
Thank you. I just wanted to be clear about that. But even if you're wrong in your personal view, in terms of the practice that's been adopted between PERC and the Crown since PERC existed, are you aware of any examples where PERC simply declined to comply with these requests or comments or instructions, whatever you may wish to call them, by the Lord Advocate?
No, I'm not aware of this happening in any other case that I've ever been involved in where the Crown has been consulted on a public statement. The problems that I spoke about earlier, which make it difficult in terms of coordinating and managing communications, tend to be around either people simply forgetting in the immediate aftermath of an incident that this needs to be done, and it's simply in good faith missed out, or it's done at the very last minute when there's no real time to consider it. Those are the issues that tend to make it problematic. This is the only example I can think of where the Crown was asked for a view, gave it, and then something else different to that happened.
Thank you. Can I ask you for your comment on part of the media statement that was released by PERC, where the Commissioner has said, she comments that it's unfortunate the family lawyer appears to have interpreted the fact that forensic pathology experts from out with Scotland have been instructed as a sign that the PERC has focused its investigation on a particular cause of death for Mr. Bio. The Commissioner can reassure the family that in fact the opposite is true. Can I ask you about that approach by PERC, if you have any concerns about that?
When you say that approach, do you mean the reference to the criticism that is being made?
The criticism in relation to Mr. Anwar and saying the opposite is true.
So I have a number of concerns. I think I have a general concern that it is unwise through the media to engage in a debate about what is happening in an investigation. Principally because I could be wrong here, but I'm making an assumption that the Commissioner had no more information than was available to the Crown, as shown in the email. In other words, we were simply being advised by the media of something that Mr. Anwar had said. Now, that's not the same thing as knowing that that's exactly what Mr. Anwar said. So I think for that reason alone, it's unwise to engage in a debate as to what was said and whether it's unwise or not. I think it goes too far in saying that something is true in relation to an investigation, because I think that is potentially confusing for people who are not yet aware of the full detail of the investigation, and I think it's therefore unwise and premature to be going into that level of detail in a public statement.
Thank you. And then just to complete our look at your answer 20, if we can just move that up slightly. That authority is traditionally exercised by Crown Office as including the authorisation of any public statement by Police Scotland or PERC when investigating a crime, given the Lord Advocate's role as head of the systems of prosecution and death investigation. This ensures consistency of messaging, and that information is only put into the public domain with the consent of the Crown. In my experience, such instructions are accepted and complied with, and it would be unusual for a statement to be issued without first obtaining the approval of the Crown. Can you elaborate slightly on the importance of ensuring consistency of messaging and information that is put out into the public domain from the perspective of the Crown?
Yes, if there is inconsistency, if information appears to people to be different or confusing because of a lack of consistency, then it could potentially create a difficulty in the investigation itself. The investigation was still ongoing at this stage, and therefore if people form a mistaken view that there is a lack of consistency or that there is a confusion in the position of the investigation, that could hinder the investigation itself. It also damages, in my experience, the confidence of bereaved relatives if they see public statements being made by different parties to the investigation which may appear to be inconsistent, and then that begins to damage wider public confidence in the validity of the investigation and its objectives.
And thinking of Article 2 and the obligations on the Crown in terms of the investigation, are these all factors that cause you concern if they do have an impact or hinder the investigation, as you've said?
Yes, if you look at it from the perspective of Article 2, then inconsistent messaging would be something that would be problematic in terms of the procedural requirements of Article 2.
Thank you. Can I ask you to look at something else now for me, please, which is COPFS 02922. And this is a letter from October 2015. So COPFS 02922. You see it's a letter to Amar Anwar, dated the 22nd of October 2015. And if we can look at the bottom of the page, you'll see it's from Les Brown, head of Cat D, and then we can see Dear Mr. Anwar at the top. and it refers to communications that have been taking place between Mr Anwar and Crown Office. I'm interested in paragraph 3 of this letter. In respect of your communication of 20th of October 2015 regarding the concerns expressed by the Bayo family in relation to media coverage, the Lord Advocate has taken the exceptional step of issuing a statement calling for restraint from all parties in the provision and publication of information in respect of the death of Mr Bayo. I attach for your information a copy of the text, and it is hoped that this will be of assistance in preventing distressing and speculative media coverage. I would also be grateful if you could, and he goes on to mention something else. And then if we turn over to the next page, you'll see a document that's been attached. The Lord Advocate today called for restraint from all parties in the provision and publication of information in respect of the death of Sheku Bayo. Lord Advocate Frank Mulholland QC said, the investigation into the death of Sheku Bayo is being conducted by PERC under the direction of the Crown, and both are well aware of all the evidence, the lines of inquiry and the issues surrounding this case. The Crown and PERC are not influenced by comments made in the media, and that is how it should be. However, speculation and a running commentary on the investigation can be upsetting to the family of Sheku Bayo, as well as the families of the officers involved. A decision will be taken at the end of this extremely complex investigation as to whether or not criminal proceedings should be raised. An inquiry will also be held at which all the relevant evidence will be heard, open to the public and the media, and it is right that it is this forum where the evidence will be rigorously tested and judicially assessed. PERC and the Crown should be allowed to get on with their job. Do you remember the background to this statement by the Lord Advocate?
I'm afraid I don't, no.
You don't. It says in the covering letter on page 1 of this PDF that the Lord Advocate had taken the exceptional step of issuing a statement calling for restraint. We've heard a number of witnesses have spoken about the Lord Advocate taking this step. Did you have any involvement in the statement or deciding whether to take this step?
I don't think I did. I don't remember the statement in particular.
You don't remember being aware of it at the time?
No.
Right. From your own experience, was this an exceptional step for the Lord Advocate to take to call for restraint?
Yes, because of my reference earlier to the fact that I'm unaware of this happening in any other investigation. Although we spoke earlier about lawful instructions, the reality is that in working together with an investigating agency on any complex investigation, there's very rarely the need for the Crown to, in a sense, fall back on the formality of a lawful instruction. The reality of the investigations is that they are professional, that the people from each organisation understand the role and are able to carry that out. And so for this to reach the stage, I'm assuming that this letter and the release by the Lord Advocate is prompted by the document we've just been looking at. I think it is exceptional in the sense of I'm not aware of that ever having happened before, that the Crown's instruction in relation to a media inquiry was not followed.
I'll be corrected if I'm wrong, but my understanding is that there were a number of tensions in being expressed and arising as a result of media commentary, public commentary by a number of bodies or persons involved, and it wasn't just specifically one statement from PERC which caused the issue. I'll be corrected if I'm wrong in that though. Can I move on then please and ask you to look at another media matter, PS 18106. Now this is from, you'll see at the top, Scottish Mail on Sunday, first edition, 23rd of September 2018. So it's a period sometime after the matters we were just looking at. It says, exclusive, officers who restrained tragic father in street did not break law. Sheku death, police cleared. And it's an article by Catherine Sutherland on the front page of the Mail on Sunday. And you'll see police officers who forcibly restrained a suspect in one of the most controversial cases in recent Scottish history will not face prosecution over his death. He lived in Scotland since childhood, pinned to the ground, carrying a knife. His death sparked complaints of police brutality and racism, and also prompted an official investigation into whether undue force was used to restrain the 31-year-old. Now, according to a well-placed source within the justice system, the country's chief prosecutor has decided the officers should not face any criminal charges. The Scottish Mail on Sunday understands the Lord Advocate believes the evidence does not support a prosecution against the officers who restrained Mr. Byle. His decision is said to be based on two main, and then if we can turn to page 6, two main factors. Firstly, the statements of multiple witnesses who confirmed the police acted proportionately. And secondly, forensic evidence that Mr. Byle's death was caused by the high levels of illegal drugs found in his system. The move will be welcomed by the police, who will see it as a massive vindication of their actions, as Mr. Byle's death is one of a number of high-profile cases where the force has faced criticism. But the decision not to prosecute the officers involved is certain to spark a furious reaction from Mr. Byle's family. The source said, and in quotation marks, "The decision has not yet been formalised, but the Lord Advocate is now confident there will be no criminal proceedings against the police officers involved." End quotation marks. The Crown Office yesterday refused to confirm the decision not to prosecute, but officials said they would soon be giving an update on the case to Mr. Byle's relatives. A Crown Office spokesman said, and in quotation marks, "We are meeting the family in the near future to update them, and it would not be appropriate to comment further at this time." End quotation marks. Can we look at, you've been asked about this in your inquiry statement.
Yes.
And can we look at that, please, which is 454, and it's paragraph 79. There. It's the headed investigation into the purported lead, I think that should be leak, to the Mail on Sunday of the decision not to prosecute.
Yes.
So, 79, a possible unauthorised release of information or documents is investigated by Crown Office under the strategic direction of the Deputy Crown Agent for operational support. And who was that?
At that time, that was me.
That was you. Who oversees all security-related matters on behalf of the Crown Agent. This includes liaison with Police Scotland's Anti-Corruption Unit. So this is a unit within Police Scotland itself.
Yes.
The nature of the investigation will depend on the circumstances of each incident, but would involve the departmental security officer and the head of cyber security. And is that two roles within Crown Office, or is it two roles within Police Scotland?
Those are two roles within Crown Office.
Unauthorised release of information may involve breaches of the Civil Service Code. Would that apply to members of staff in Crown Office?
Yes.
Professional standards. We've heard that a number of them are legally qualified, so they'll be obliged to comply with the professional standards applicable to solicitors.
That's correct.
Breaches of data protection legislation, which requires Crown Office to keep personal data secure. And other possible criminal offences. If there are reasonable grounds to suspect that a member of staff has committed a criminal offence, then the police will be instructed to investigate and report. There is no difference between an investigation into the unauthorised release of information and of documents. Each investigation will reflect the individual circumstances of the incident. So if it's a possible criminal offence, the police would be involved. If it's a breach of professional standards, that would be a matter for the Law Society of Scotland rather than the police.
It would also be treated as an internal disciplinary matter.
So there may be other aspects which may not be potentially criminal, but which Crown Office would look at internally in any event.
Yes.
Thank you. Paragraph 80. Sorry, there's one other thing I wanted to ask you about that paragraph. If we can go back. I think there was a reference to reasonable grounds. Sorry, I don't have a note of the... There they are. It's just below halfway. If there are reasonable grounds to suspect that a member of staff has committed a criminal offence. Do you see that line?
Yes.
What would reasonable grounds amount to?
Reasonable grounds could be, for example, preliminary indications that a member of staff had accessed a case that they had no entitlement to access, or it could be information from another member of staff who thought that they had seen a colleague do something or speak to someone, or it could be information from outside the organisation. So it would be a broad range of possible circumstances that would give you reasonable grounds to suspect that a member of staff had done something, and therefore there was something to investigate, a line of investigation which could be followed.
Thank you. Looking at answer 80, I do not recall being aware of the article ahead of its publication. On many occasions the media will ask for comment ahead of publication, but I cannot find any evidence of this having happened in this case. I review the media each weekend for reporting relating to Crown Office, and it is highly likely I was aware of the article on Sunday the 23rd of September, but I have no recollection of that. I'm interested in you've said on many occasions the media will ask for comment ahead of publication. How would you normally go about finding out if somebody has provided comment from Crown Office?
Sorry, that reference is to just simply the routine requests that media will send us to say. They will often say that they are planning to publish a news article about our work, and they will give us the opportunity to offer a comment to be included in that. So we regularly would see. It's rare to see a published story which we did not know was going to be in the media. That's what I meant in that sentence.
Right, but you don't recall being aware of it ahead of the publication?
Not on this specific example, no.
And when we looked at the article itself, it did appear to provide quotations from someone in Crown Office who refused to confirm the decision not to prosecute, but said they would be soon giving an update on the case to Mr. Byles' relatives, and we're meeting in the family in the near future to update them. Did you find out if those comments had come from someone in Crown Office?
I would need to look at the article again just to be sure, but I think what you're referring to would be the official response that the Crown Office provided to the article in the way that I've described. So on the Friday, the Mail and Sunday would contact us and say, this is an outline of what we're planning to say. They don't share the entire article, but they would provide an outline in any specific part that related to our work, and they would invite us to offer a comment, and we would provide that in the expectation that they would then publish that. So I think what you're referring to is the response that we provided for inclusion in the article.
So let's look at the article again, PS 18106. And if we can look on page 6, you'll remember I read out the section where
so
it says on the left hand side, the Crown Office yesterday refused to confirm the decision not to prosecute, but officials said they would soon be giving an update on the case to Mr. Byles' relatives. A Crown Office spokesman said, we're meeting the family in the near future to update them, and it would not be appropriate to comment further at this time. So those comments appear to have come from Crown Office. Would that indicate that the paper had been in touch with Crown Office for comment in advance of publishing the article?
Yes, and I would distinguish that comment from there's a paragraph above with quotes in it, but that's not to be confused with the Crown Office response.
No. I think it says the source said
yes.
for those comments.
Yes.
But these are, it says the Crown Office yesterday refused to confirm, but then gave an update on the case.
Yes, I mean the reference to yesterday suggests they may have asked on the Saturday rather than the media team in Crown Office provide a
and did you,
out-of-hours service.
Did you look into who the Crown Office spokesman was on a Saturday? provide those comments to the newspaper?
No, that wasn't something I was concerned about.
Right. Okay. We were on answer 80, I think, on your statement. And then line 5, from reviewing emails which you have asked me to consider, I can infer that the issue was first raised with me officially by Lindsay Miller on Monday the 24th of September, so that'd be the Monday after the article has appeared.
Yes.
In her capacity as Deputy Crown Agent, Serious Casework, following a conversation she had with the Lord Advocate. I do not recall being involved in this conversation, and there is no indication in the emails I've reviewed that you were involved. I do not recall any action being taken on the day of publication, and I have no records to indicate that anything was done on the 23rd of September. Obviously, given the nature of the article, that I know a prosecutorial decision has been taken not to prosecute police officers, would you have expected something to have been done by the Crown on that day?
The 23rd of September was obviously a Sunday. I would have expected the senior officials, prosecutors who were involved in the relevant case to be discussing it and assessing it. And my recollection is from looking at the material provided to me by the inquiry that there was an exchange, I think, between the Lord Advocate and Lindsay Miller on the Sunday about the newspaper article in the way that I was describing. So in my experience as a prosecutor, if there's any weekend media reporting of any case that I'm involved in, then I would be looking at it and dealing with it at the weekend when it happened.
Are you aware if anyone took the step to contact the family?
By this stage, I wasn't involved in any way with the investigation or with any of the dealings with the family, so I'm afraid I can't answer that. The role that I was performing at this time I had moved into in sometime between April and June of 2016, so approximately a year after Mr. Bow's death, and Lindsay Miller had succeeded me as what was now called the Deputy Crown Agent role for serious casework, but that was essentially replacing me in the role that I'd been performing in May 2015.
Thank you.
So I'm afraid I can't help you with any answers to the question as to whether there was contact with the family on the Sunday.
We've still to hear from Lindsay Miller, but can we move on to the next paragraph, 81? So this explains your involvement in this matter and your role in the matter. You say, I've explained my role as Deputy Crown Agent for Operational Support in answer to question 79. Following my discussions with Lindsay Miller on the 24th of September, I assumed strategic responsibility for carrying out the Lord Advocate's instruction to determine if confidential information about the death investigation had been provided to the media in an unauthorised manner. So were you brought in to conduct this investigation?
I'm not sure being brought in quite captures how this works. My responsibilities in the role at the time as Deputy Crown Agent for Operational Support included questions of professional standards, security, data protection, a range of issues. The role I was performing at the time was essentially a corporate role, so I wasn't exercising any prosecutorial function. And therefore, the matter was referred to me because it was within my responsibility to carry out that investigation. But of course, given that Lindsay herself was carrying out a role which gave her responsibility for the investigation, it would have been inappropriate for her to carry out any of the investigations. And so I was asked to carry them out, both because it was my role and because it was thought appropriate to have a degree of separation from the team who had been involved in the death investigation up until that point.
As yours was, as you put it, a corporate role, does that mean you had a responsibility to protect the corporation?
I mean corporate in the sense of I had leadership responsibility for what we would refer to as the corporate functions of the organisation, which included HR, finance, IT, as well as security, policy, and a range of other issues. The responsibility you're describing, I think, is what I would say that was a shared responsibility amongst the entire senior leadership team, that part of being in that senior leadership team is to take steps to ensure that the reputation of the organisation is not damaged by any of our work.
Okay. So you were not in the role of an investigative body looking to investigate whether any offence had taken place or there had been any breach of standards of some description?
I instructed colleagues who had the means to do this to carry out preliminary investigations to see if there was any indication that a member of staff had inappropriately shared information. If I had found information that had happened, I would have immediately commissioned an internal disciplinary investigation, and if I regarded it as being a criminal matter, I would have instructed the police to start a criminal investigation. There were other occasions where I did that in relation to allegations of information handling, where I concluded that a member of staff may have committed an offence. I instructed the police carried out an investigation. They did not report to me because I was not acting as the prosecutor. I gave the instruction to carry out the investigation, given my responsibility for security, but it was then reported to a prosecutor with no previous involvement in the matter, and they would then take a decision.
So you've said you instructed colleagues who had the means to do this investigation. Who were those colleagues?
I've referred to them in my statement. They were colleagues who had principally access to our case records and our communication information, and therefore they were able to carry out preliminary inquiries to determine whether there was any indication that someone had acted inappropriately. Right.
Let's look through the remainder of paragraph 81. I concluded that there was no evidence of this from our case management and communications data, that there were no reasonable grounds to carry out interviews of members of staff or instruct a police investigation, and that information about the decision and the timing of a meeting with Mr. Bai's family was known to individuals outside Crown Office, for whom I had no departmental security responsibility. In all the circumstances, including the nature and content of the newspaper article, I determined that it could not be concluded that a leak in the sense of an unauthorised release of information by a member of Crown Office staff had taken place. Lindsay Miller was Deputy Crown Agent for Serious Casework, and as such had strategic responsibility for the investigation into the death of Sheku Bayo at the time of the article. She drew the article to my attention in that capacity. You refer to the Departmental Security Officer, who carries out all security-related investigations. Is that one member of staff that you instructed to carry out this investigation?
Yes.
And then you also refer to the head of cyber security, who's responsible for all aspects of digital security. And is that the second member of staff who carried out this investigation?
That's correct.
And that included analysing digital case-related and communications information for evidence of security incidents. So those were two members of staff, head of Departmental Security Officer and head of Cyber Security, who were involved in doing the investigation. And when you said they had the means to do this, would they have had the means to investigate all aspects that you've talked about? Criminality, data protection, professional standards breaches, that type of thing?
Yes, and the normal way of carrying out these inquiries is that they would not exercise those investigative abilities without authorisation either from myself or from HR. They would only do this on instruction.
And as well as looking at the data that you've mentioned, the case management and communications data, did they speak to any staff about this matter?
No, I'm not aware of them speaking to any of the individuals who were involved in the investigation.
And did either of them speak to the Crown Office spokesman or spokesperson who had been contacted by the newspaper? It appears to say on the Saturday.
No, I set the scope for them to carry out their work, so they were doing what I had asked them to do, and I did not make any connection between the security investigation and the spokesperson who had provided the media response.
Right. And was there a particular reason not to ask that person for any information about the discussion with the newspaper?
I didn't regard that person as being in any way possibly responsible for any information being provided, because they were acting in response to the newspaper coming to us with the story, and therefore the newspaper already had the information and the story written. So it seemed to me that the person in the media team, I can't say that I gave it any thought at the time, and reflecting on it now, I can't say that the person in the media team would have had any responsibility, possibly any responsibility for that information being provided to the newspaper.
And were you content that the information they provided to the newspaper about the meeting with the family was a reasonable response?
On the face of it, it appears to be exactly the sort of information that they wouldn't, for something like that of this nature, they wouldn't act on their own in responding to a media inquiry, particularly if it came in on a Saturday. We have an established procedure for the media team to contact senior people, particularly senior people involved in any high-profile cases such as this. So it is only an assumption, but my assumption is that that media response would have been shared with and approved by someone outside the media team before it was given to the newspaper.
Right. But that wasn't checked?
I wasn't part of that. I wasn't part of the investigation or involved in that media work, so I can't say whether it was checked or not.
I'm going to move back to the article for a moment, but I'm also conscious it's now 3 o'clock.
We'll take a 15-minute break at this stage. Ms Graham.
Thank you. We were going to briefly look again at the article, if I may, which is PS 18106. And just at the end of the first page, it talks about two main reasons. His decision is said to be based, that's the Lord Advocate, on two main, and then we move on to page 6. Just further down. Two main factors. Firstly, the statements of multiple witnesses who confirmed the police acted proportionately, and secondly, forensic evidence that Mr. Biles' death was caused by the high levels of illegal drugs found in his system. You've talked about the investigation which was carried out, which you instructed by the head of cybersecurity and the departmental security officer. Did their investigation include looking into whether those two factors were correct?
I think there was an initial assessment at the beginning as to whether or not there was anything in the newspaper article which could only have been reported as a result of an unauthorised release of information. And that included an understanding of, given that none of us were involved in the investigation or aware of the conclusion of the investigation at that point, included an assessment of both of those factors in relation to the final decision making. But I can't remember precisely how that was done, or but it was an important part of trying to understand the scope of what we were dealing with, and it took place at the very early stages, probably on the first day, the 24th.
Do you remember the outcome of that aspect of the investigation?
I remember a general conclusion was reached that there was nothing in this article which could only have come either as a direct quote from a document which had been seen by someone, or a very, very specific piece of information which was only known to a small number of people involved in the investigation. And therefore that presented certain difficulties in terms of trying to understand whether or not, in fact, there had been, to use a term that's commonly understood, a leak of information or not.
So in relation to these two factors, the statements of the witnesses and the forensic evidence, are you suggesting that could have come from some sort of authorised release of information?
This is only my recollection as it stands now, but my recollection is that those were both factors that had been commented on publicly. It was a matter of public understanding that the investigation was looking at whether or not the actions of the police officers amounted to a criminal offence, and that included close examination of forensic evidence.
Right, because what it said in the article is the two factors, the reason for the decision not to prosecute, are the two factors. Firstly, the statements of multiple witnesses who confirmed the police acted proportionately. Are you suggesting that it was public knowledge and there had been authorised public statements that there were statements from multiple witnesses who confirmed the police acted proportionately?
No, I'm not suggesting that. I'm suggesting that it was public knowledge that that was an issue that the investigation was considering.
But what this says is there were statements of multiple witnesses who confirmed the police acted proportionately. It doesn't say the Lord Advocate is considering whether the police acted proportionately. It's saying that one of the two key factors for the decision not to prosecute is statements from multiple witnesses who confirmed the police acted proportionately. Do you see the distinction there?
In terms of considering whether or not that comes from an unauthorised release of information, I'm not sure I see the distinction. The key point, from my point of view at that stage, was that neither of those two factors appeared to me to be specific pieces of information which could only have come from the investigation.
All right. There's also a comment that, do you see it says the source said the decision has not yet been formalised, but the Lord Advocate is now confident there will be no criminal proceedings. Do you see that?
Yes.
Do you have an understanding of what that meant, the decision has not yet been formalised? Would there have been another step to the process before it was formalised? Once the decision has been taken not to prosecute?
Well, as I've said, I wasn't involved in the investigation, so I'm not precisely sure what stage it had reached, but my understanding was a decision had been taken that there would be no criminal proceedings. And our processes had evolved since by that stage to include a victim right to review. So I'm assuming, therefore, I'm making an assumption here because I wasn't involved, that there would have been a process of victim right to review which would have followed on the communication of that decision to the bereaved family.
So it would be correct to say that although the decision had been made, there would be another part to the process that could take place after that decision had been made?
Yes, but equally I did not regard that as information that must have come from the investigation because that was a publicly known process which had been adopted as a result of legislation. So it was widely known that that's what the process now involved.
Can we go back to your statement, please, for a moment, and in particular paragraph 82. You're talking about the 24th of September. I have a general recollection of the investigation which followed, its scope and nature and the difficulties to which Miss Miller alludes in her emails. These difficulties included an inability at the beginning to identify anything from the newspaper article which could identify any document or other source of an unauthorised release of information. So was the investigation looking to see if there was a document which had been copied and pasted, in other words, or an extract from a document?
That was one possible line of inquiry. So, for example, if the newspaper article had included a direct quote from a document which had never gone outside the organisation, then that would have allowed the investigation to move forward in that direction. So it was one possible, but not the only line of inquiry.
Furthermore, the nature of the article in which it was claimed that a source in the justice system knew of a decision in a case which had been highly publicised over 3 years, including reporting of the details of the incident involving Mr. Bayo's death, and by its nature could only be a decision either to prosecute or not, left a question in my mind as to whether anyone involved in the investigation, or with access to information about its conclusion, had released information in an unauthorised manner. I also observed that a meeting between Mr. Bayo's family and the Lord Advocate had been fixed for the coming days, and this was known to people outside Crown Office. Did you have a view about, you said the difficulties included an inability to identify anything from the article which could identify a document or other source of an unauthorised release. Did you not consider the quotations from a source in the justice system to be sufficient in itself?
No, I didn't, no.
And why was that?
Because there was nothing in the quote from the source which directly indicated that there had been a release of information, and nothing beyond that which could be investigated. It was simply an anonymous quote which was describing a process.
Did anyone get in touch with the newspaper to speak to them?
I don't know whether it's changed, but in my time carrying out investigations into matters like this, then I would not approach the newspaper because I would have absolutely no expectation that the newspaper would in any way provide any information about the source of their reporting.
From what you've said, did you think that there was no source?
I think I tried to be clear in my statement perhaps later on that I was unable to reach a conclusion on this matter. I could not find anything which determined that someone in Crown Office had released information in an unauthorised manner. I was able to establish that the broad thrust of the information that was reported was known to people outside of Crown Office. And I was also of the view that the nature of the article, taken at its broadest, was that in the knowledge that the family had been invited to a meeting and that it was my recollection that the investigation was reaching its end was publicly known, it simply was a matter of speculation or guesswork to conclude what the conclusion of the investigation would be. And so therefore, putting all of that together, I could see nothing that allowed me to determine, first of all, that there had been a release of unauthorised information, and secondly, if there had, that it had been someone in the Crown Office that was responsible. But I couldn't rule it out.
Was the end, you've said the end of the investigation, it was publicly known. Was it publicly known that it was nearing the end of the investigation?
My recollection at the time was that there was public speculation in the media that the investigation was coming towards its end. I could be wrong in that, but that's my recollection of where things stood in late summer, early autumn of 2018.
Did Crown Office comment to confirm that an investigation is coming to an end normally?
No, we would not, no.
And just to be clear, just below halfway down the page as we see it on the screen, you did say knowledge of this meeting in itself. Do you see that?
Yes.
Knowledge of this meeting in itself coming towards the end of the investigation may have caused people in the justice system or journalists to speculate about the decision. So are you saying here that you think people just speculated, just made up what they thought the decision was?
It's a possibility.
And in making that up, they decided not to prosecute. Was that a lucky guess?
Well, as I say, the conclusion was either to prosecute or not to prosecute. There had been significant media interest in this investigation over a number of years. It seemed to me that the nature of the story, which was the conclusion of the investigation and the decision, could easily just be speculation about what the decision would be. And that in itself did not help me in determining how to proceed with the investigation. I have to emphasise, had there been any basis to carry out further investigation or to take this further, then I would have done that. There were a number of investigations I carried out at that time where I, as I said earlier, I called in the police. So the only thing that was preventing me from taking this further was any basis to do so.
Although from the headline and the references to a source, it's not presented, would you agree, as if it was speculation?
You're asking me there to comment on how the media present their stories, and I'm afraid...
Maybe going too far there.
I think I'm probably limited in any observations I can make, but I can say in my experience, in almost 30 years, I have seen many, many stories in the media about our work, which, in my view, have never amounted to more than speculation, and in many cases have been completely inaccurate. And that continues to this day.
Right.
It is, unfortunately, the nature of the confidentiality of our investigations that people will speculate and the media will reference sources which are unnamed, and I'm afraid it's something we've had to learn to live with in terms of how we carry out our investigations, but it's particularly difficult for the families in cases such as this.
All right. Can I ask you generally about the investigation then that was carried out? Was it part of the investigation to identify all the individuals in Crown Office who had the information about the decision not to prosecute?
Yes, that was established very early on, I think, on the first day, because that was then able to be used in order to define the follow-up inquiries which were undertaken. And
was it also part of the investigation to identify who'd been given or was in receipt of that information out with Crown Office itself?
Yes, that was one of my questions, and that was answered. I couldn't carry out any inquiries in relation to that aspect of it, but it was important to my work to understand, was this information that was only known within the organisation or outside the organisation.
And were you satisfied that those who had been told of the outcome of the prosecutorial decision out with Crown Office, that they were properly in receipt of that information?
Yes, my recollection is that the sharing of the information was appropriate and limited, I can't remember how much of the detail I knew of it, but I was satisfied it was an appropriate sharing of information as opposed to unauthorised.
Did you consider whether to interview any of the staff who were within Crown Office who were aware of the prosecutorial decision?
I gave consideration to that, but I concluded that there was no basis for doing that.
And did you consider whether to invite the police to investigate the matter?
I always had an open mind on that, and if I'd reached the stage where I thought it was appropriate to do that, then I would have done that. And as I've indicated, I did that in a number of other investigations which led to prosecutions of members of staff for committing offences in relation to their work. So I would have done that if there had been an appropriate stage reached, but I determined there was no basis for asking the police to carry out a criminal investigation.
And as you said in paragraph 79, there was normally there'd be liaison with Police Scotland's anti-corruption unit. Was there liaison with the Police Scotland's anti-corruption unit?
On this specific issue?
Yes.
Yes, no. Sorry, there was no specific, rather than say yes, no, there was no specific liaison in relation to this matter. I concluded there was no appropriate basis to ask the police to investigate.
Right. So in paragraph 79, where it says a possible unauthorised release of information or documents is investigated by Crown Office, that be under your direction, and where you say it includes liaison with Police Scotland's anti-corruption unit, why was there no liaison with their unit on this occasion?
Because, so there are two aspects to that. What I'm trying to describe there is that in that general role which I occupied and the way I carried it out, there was general ongoing liaison. So I had quarterly meetings with Police Scotland's anti-corruption unit throughout that time, where I reviewed with the police anything that would be of concern in relation to security in the organisation. So that's part of what I'm trying to describe there. I wasn't trying to indicate that on this specific matter there was liaison with them. There wasn't on this specific case because I concluded there was no basis to ask the police to carry out any investigation. There was nothing and no one to ask them to investigate.
Right. Did you specifically speak to the unit or anyone from the unit to discuss it with them?
No.
And then in relation to the meetings with the family, we have the inquiry has details about a number of meetings that took place between May 2015 and the 3rd of October 2018. Were you concerned that the newspaper appeared to realise that the 3rd of October 2018 meeting that was coming up after this release would be the final meeting in relation to the investigation? Was the timing of that final meeting of any concern to you?
It was of concern to me primarily because of the impact this would have on Mr. Bow's family who would be coming to that meeting. I had experience in other cases of, in the build-up to critical events and cases and investigations of media reporting and the impact that that had on families. So that was a particular concern of mine.
Finally, paragraph 82, I think, was the final paragraph that you dealt with this issue. And we were looking through that. And you say, I do not recall any example of a member of staff. So let me just see where that is. Sorry, I've not.
I think it's further down.
Is it further down? Sorry, thank you. It's single line spacing, so it's quite. There we are. Yes, it is. Journalists regularly claim to have unnamed sources who are reported to know confidential information. In my experience, insofar as this type of reporting relates to the work of Crown Office, it is either inaccurate, speculative, or simply opinion and guesswork on the part of journalists or those in the justice system with whom they engage. It is reported by the media as fact, but in my experience working in Crown Office, I do not recall any example of a member of staff releasing confidential information to the media, or any such media reporting demonstrating that a member of staff could be the only source of an unauthorised release. While I fully understood and sympathised with Mr. Bio's family at the nature of the media reporting, the content of the article and its impact on their confidence in the investigation, I sought to give effect to the Lord Advocate's commitment that the matter would be investigated. The circumstances, however, insofar as they could be investigated internally within Crown Office, did not allow me to conclude that a member of staff had been responsible for a release of unauthorised information, or even that such a release of information had taken place. And then you reported that. Are you aware of any examples in your own experience in Crown Office of Crown Office staff releasing unauthorised release of information to the media?
No, I've never been aware of that. I'm aware of media articles which claim to source work from a source or an unnamed, and some to go as far as saying someone in Crown Office, but I've never been aware of an actual example of that happening and it being demonstrated that a member of staff has shared confidential case-related information with the media.
All right, thank you. Could we move on now, please, and look at COPFS 03988. And you'll see this is, again, emails from you, this time to Lindsay Miller, and it's dated 24th of September 2018. So it's in the day after the media, the article we've just been looking at. And if we could look at page 3 of 5 first of all. So this is from Lindsay Miller, 24th of September 2018. As you know, I'm after some advice from you about how to deal with recent developments in the above case. You may be aware of some of the coverage of the apparent decision in the above case. The formal decision has not been communicated by the Crown to the family, and the Lord Advocate is both concerned and disappointed that such detailed speculation has appeared in the media before the meeting with the family, which is scheduled for the 3rd of October. I can confirm that a minute setting out particular options on next steps was sent by the Lord Advocate to the Cabinet Secretary for Justice in early September, and Les Brown and I have had some discussions with Scottish Government officials about what the various options, eventualities, timescales would be, depending on the decision. And so this is conversations that are going on out with Crown Office about next steps in relation to the decision which has been taken.
Yes.
If we can move up the page, please. And then it talks about a group within government. Then it says, the Lord Advocate has asked that I commence an investigation into this purported leak, and I'd be grateful to you for some advice on how you see that this might be carried out at Crown Office end. And I'm waiting a call back from the relevant Deputy Director at the Scottish Government about what, if anything, they're planning to do. And if we can just look at the bottom, it should be from Lindsay Miller. Lindsay. Can we move up the page, please? I'm looking at page 2 of 5. And then this is an email to Lindsay Miller. You've been CC'd into this email. Thanks, Lindsay. The source is allegedly within the justice system, but I believe that I would be able to give you a report that would cover the Crown Office side with enough to say that checks have been made and we are satisfied that the leak did not come from us. Obviously, we can only work with what we have. If you're in agreement, I can do some background on the reporter's social media presence. I would need the names of all our staff who were in both the discussions and the email chain with their phone numbers. To start, I will check if there has been any traffic, either by email or telephone, to the reporter or the news desk at the paper. I will check on any friends within social media for any connections. Whilst I appreciate this is a lot of ticking the boxes, it may give the Lord Advocate a bit of reassurance. Can I ask you about the tone of this email? If we can look at the top again, there's the I will be able to give you a report that will cover the Crown Office side with enough to say that checks have been made and we are satisfied that the leak did not come from us. So again, the approach that's what's expected. And then at the end, this reference to box ticking, if we can go down the page again. Sorry, it's over 2 pages. A lot of ticking the boxes, but it might give the Lord Advocate some assurance. Can I ask you about the tone of this?
Yes.
Was this investigation being carried out with an open mind, with a determination to find out the truth? Or was this some sort of box-ticking exercise to simply reassure the Lord Advocate?
It was carried out with an open mind, and I should have indicated in response to your earlier questions, I am in absolutely no doubt, had I found the slightest indication that a member of staff had released information in an authorised fashion, then I would have taken the steps that I'd indicated earlier. There would have been no question of doing anything other than that. The tone of this email and the reference to ticking the boxes, I think, is an indication that elsewhere in the email, I think you had read out earlier in Lindsay's earlier email that she and I had discussed, and or you maybe didn't read it out, but it was in the email that Lindsay and I had discussed, and we could see that there were difficulties in this. We could see the limitations that I have talked about this afternoon, and I think that's all that the tone in this email is directed towards, is that it's not in any way determining what the outcome is. It's indicating that there are limitations in what we can do. If you think about it as a matter of logic, if for a moment you consider that a member of staff had broken the law and released information in an authorised fashion, they were first of all extremely unlikely to have used any of our systems to have done it, because all of our staff are aware that we regularly check our systems for security purposes. We monitor email usage, we have access to email and telephone records. So the security officer who's written this email, who was an experienced police officer before he joined the Crown Office and Procurator Fiscal Service, myself and Lindsay, I think, had reached the conclusion that we would check everything we could with an open mind, and if we found something, we would absolutely do something about it. But even allowing for the possibility that someone had broken the law here, they were unlikely to have done it in a way that would leave something that could be found. But that wasn't a reason not to do it. We would absolutely go ahead and do it. So I think that's all that the tone of this email is really getting at. And in terms of ticking the boxes, as I said in my statement, I don't think that's intended to indicate that anything is perfunctory or less than adequate. It's just simply an indication that there are limits, and in the absence of a reason, for example, for a police officer to interview someone as a suspect, then you're extremely unlikely to achieve the sort of outcome that some people might imagine is possible in an investigation like this.
Well, let's go back up to page 2 of the email, because I think you, from Lindsay Miller, sorry, thank you. Again, you're CC'd into this. It says, JTL, I believe that's you, and I, Lindsay Miller, will discuss further before I come back to you, as there will be some significant HR implications here too. And then if we can move up again, please. Here we are. And this is an email from you on the 24th of September 2018 to Lindsay Miller. And you say, our checking can only really involve interviews of the staff who were aware of the decision and checking of their corporate email and phone logs. With appropriate support from Scottish Government, we could do something similar for any staff in Scottish Government who were aware or had been given an indication of the possible outcome. We're unlikely to find anything from these checks. My real concern is that this is not the normal sort of leak which generates a leak inquiry. We should really only undertake such an inquiry where we can establish there has been a leak. Nothing about the story allows us to do that. There are only 2 possible decisions, and the family were aware they were coming to a meeting in 10 days to be told the decision. It could easily have been a guess on the part of the journalist, written up as a leak. Can I just pause there? When you say, my real concern is that this is not the normal sort of leak which generates a leak inquiry. Can you explain to us what a leak inquiry is and how that differs to what was done here?
Yes, a leak inquiry, as it is commonly and publicly understood, would be the sort of inquiry that would lead to a civil servant being prosecuted, and there have been examples of that, prosecuted for breaching the Official Secrets Act and being imprisoned, and a leak inquiry is carried out. So there are examples of that having been done in the past. My understanding of those and recollection of them is that they are derived from examples where very sensitive information is made public in a way that it is clear it could only have come from specific documents or from a small, it is so specific it could only have come from a small group of people who knew it. And in those circumstances, that is essentially what guides the investigation, and you can then investigate. As we've talked about already this afternoon, and what I'm describing here in a sort of shorthand way with colleagues, is my initial assessment, although I had an open mind on this, my initial assessment was we were not in that territory, and it was unlikely to move into that territory unless we could find something. Now, I wasn't ruling it out that we would find something, but I regarded it as unlikely, as I said. But had we found something, we would have immediately moved to the next more formal stage.
All right, thank you.
So, for example, if we had identified that a member of staff involved in the case had telephoned the journalist in the week before, then I would have taken further action in relation to that, or if I could have identified an email trail and a point of contact, but none of those things were established.
Or I think earlier you said a direct quote from a document.
Yes, if there was a particular turn of phrase or a particular piece of information which was only held in one document and not known beyond that document, that might be a useful indication as to who had access to that document and what did they do with it. And that would have been a basis to carry out, as I indicated in that email, perhaps interviews either internally or with the police.
Right. I'd like to move on to something else that you've mentioned today, actually. You don't recall any examples of any member of staff releasing confidential information to the media?
I don't.
Crown Office staff?
No.
And in paragraph 82 of your inquiry statement, I think you mentioned that. And we see it on the screen now. I do not recall any example of a member of staff releasing confidential information to the media or any such media reporting demonstrating that a member of staff could be the only source of an unauthorised release. I'm interested in your experience of any other types of release of information and this type of investigation being carried out by the Crown. Am I right in thinking that you were aware of the leaks of information primarily in relation to two reports that had been prepared in the Chokar inquiry?
No, I'm sorry, I had no involvement. And I don't recall anything about any leaks of or unauthorised release of information in the Chokar inquiry, so I'm sorry, I can't help you with that.
Do you remember, I'll ask you this to see if it prompts any memory on your part, that, well, you said you started in Crown Office in '94 and this occurred in 2001.
Yes.
That there were two reports in relation to the Chokar inquiry, one by Raj Jandu
Yes.
and one by Sir Anthony Campbell, a judge from Northern Ireland.
Yes.
And there were leaks in relation to both those reports prior to the family being informed as to the outcome of the reports.
I have no recollection of that at all, I'm sorry.
You've none?
No.
All right.
Just to explain, I was, yes, well, I'm not sure the timing of that, but that may have been because of the duties I was performing at the time that I wasn't aware, because there was a period of time where I wasn't performing normal prosecution duties in this country.
We have other witnesses coming, don't worry, I can speak to others about that. Were you conscious at the time of this leak, and I think you've mentioned the family, as to the impact this leak would have, or non-leak, would have on the family?
I think
Sorry, whether leak or speculation?
Yes, I think my experience over many years has been that media reporting, particularly in the build-up to significant events in cases or investigations, is extremely distressing for families. And in the past, that has included releases of information, authorised releases, official releases of information. I have a general recollection in the past that the Crown may not always have advised the family before information was put into the public domain, and we've had to learn the hard way the damage that causes in terms of confidence. I can't give you any specific examples at the moment. So I have experience and recollection of that, and experience and recollection of what I have termed speculation by the media, or by people that the media are quoting as to what the Crown is going to do, or what's bound to happen, or what the outcome is going to be. And all of that is incredibly damaging to the confidence that families will have, because from their perspective, they may well assume that simply because something's reported in the media, they're assuming it's true, and therefore it potentially misleads the family as to the accurate state of affairs.
Of course, in this particular occasion, the speculation or the leak was true. Were you also concerned about the implications for the wider public confidence in relation to leaks or speculation coming from a Crown investigation?
Yes, that would be why I think I said earlier that if I had found a basis to do it, I would have taken this very seriously. It would have been for that reason, because I would have wanted to maintain public confidence and demonstrate that if something had gone wrong, that it was dealt with appropriately and severely.
Can I ask you to look at, first of all, at some questions in the Rule 8 request? So I'm moving on to particular questions in relation to family liaison, and from an Article 2 perspective, the next of kin. So questions 34 to 39. And you're asked about family liaison here, and your understanding of Crown Office's role in liaison with the deceased family in death cases. How does Crown Office role interact with the role of Police Scotland and PERC, duties and responsibilities? And then you're asked to look at an email chain between you, the Crown Agent, Miss Catherine Dyer, and Mr McGowan of 6th of May 2015. And a number of matters along those lines. Carry on. You were asked about what involvement you had in family liaison in relation to Mr Bio's death. And then again you're asked some questions in paragraph 38 and about VIA. Can I ask you, can we look at your answers, please, to those questions, and primarily answers 34 and 35. So this is where you respond to these questions on family liaison. Communication with the deceased family during an investigation is a critical part of the investigation. It allows the Crown to share information, keep the family updated on progress, and ensure that they have an opportunity to contribute concerns or views on how the investigation should be conducted. These can then be considered by Crown Office in reaching an independent view on the manner and extent of the investigation and its conclusions. The Crown's role in such communication must be carefully coordinated with any family liaison put in place by the investigating authority, be it Police Scotland or PERC. So just for those listening, Crown Office doesn't have its own family liaison officers. They are engaged by either PERC or the police where appropriate.
That's correct.
But an organisation that the Crown do have communication with is VIA. And can you give us a little bit of information about VIA?
So VIA is the shorthand term we refuse to refer to our own service. So colleagues in the service who have direct contact with victims in criminal cases and with bereaved relatives in death investigations work within what we refer to as the Victim Information and Advice Service, and so they are the dedicated staff who will prioritise communication with bereaved families in death investigations. And at the point where the responsibility for the investigation moves from the investigating agency to the Crown, there is traditionally a handover of the responsibility for the contact with the bereaved families. from the family liaison officers to the VIA staff in the fiscal service. And one of the things we've learned over the years is that it's very important that that is carefully planned and coordinated, because if it's not, then it risks the family being confused as to different organisations and the responsibility. That's very unhelpful from their point of view. So it's that handover is a critical part of the investigation as far as we're concerned.
Can you help us understand, when does VIA's role begin? At what point? Is it before criminal proceedings, or regardless of whether criminal proceedings are instigated, or after they've commenced?
In prosecutions, VIA is notified at the point where a decision is taken to prosecute, and in the majority of our cases that's at the very beginning of the case. They will also become involved in cases where the Crown's carrying out its own investigation, and the panel appears on petition, and there is an investigation before the prosecution begins with the service of the indictment. So VIA will be in contact at that stage. In death investigations, the contact with VIA starts at the point where the Crown assumes responsibility for the investigation as a result of the agency reporting the death.
So in this case, we've heard that the final PERC report was sent to Crown Office in August 2016. Can you help us understand when VIA would have been involved, or were they involved with the family?
So I can't help you. I can't help you on the actual engagement in this case between VIA and Mr. Bow's family, but I would have expected, on receipt of the report, my expectation would have been that the VIA colleagues would have become increasingly involved from that point on, because we would have regarded as the PERC investigation as essentially complete, and it was thereafter the Crown's responsibility to draw the investigation to a conclusion.
So at that point that the Crown investigation commences, and PERC have stepped back having delivered the report, that is the point at which VIA would have had some engagement, if any.
That would be my expectation, yes.
And then you say at 35, I do not know if there was a handover of family liaison from PERC to Crown Office. The duty of Crown Office in any death investigation, whether involving PERC or not, is as outlined in my answer to question 34. Engaging meaningfully and effectively with the deceased family ensures that they have confidence in the investigation and its outcomes, and satisfies the Crown's obligations in terms of Article 2 of the European Convention. So you see an engagement with the family as an important part of an Article 2 compliant investigation.
Yes. For me personally, I think that's one of the principal learning points for the organisation over the last 15 to 20 years has been the importance of that engagement. And I should stress, in talking about our VIA staff, I would not necessarily expect the engagement with the family to be limited only to the VIA staff. In a lengthy, complex investigation, I would expect the investigators, the lawyers involved, to also build up a relationship with the family over time.
We've heard much about the Lord Advocate's engagement with the family, and we'll no doubt hear more in due course. We've heard less about VIA's engagement with the family. Were you aware of any engagement that was going on during this period?
The extent of my awareness was that initial contact by the Lord Advocate, which was facilitated by the service, and in some cases direct with the Lord Advocate himself, because the Lord Advocate was very clear in a way that we understood that there was a particular need in this case for the Crown to do all it could to try and ensure that the family were confident that the investigation would be independent and would be effective. I have no recollection as to the extent of any VIA staff involvement in that, whether they were present at these meetings or not. It's possible they may have been, I'm not sure. But I wouldn't have expected them in the ordinary course of events to become involved until after the report had been received.
Paragraph 36 does say the Lord Advocate explains, if we can move down. Oh. No, sorry, this was the question. I'll move on from that. We have heard some evidence that the family were given what was described as exceptional disclosure and by Crown Office in relation to the question of experts, disclosure on an exceptional basis solely to enable them to instruct their own medical experts. But there was comment made, and we've heard evidence from Les Brown that that was given to the family in this case. Were you aware of that exceptional sort of access when Frank Mulholland was Lord Advocate to the family?
I was, in a very general sense, I was aware of that, and it was driven by some of those early discussions that I think I referred to earlier, which took place in the immediate aftermath of Mr. Bayou's death, including in discussions with the Lord Advocate, where I think it was clear to all of us that, although, as I said earlier, I don't recall any other death of a man in these circumstances in Scotland, it was clear to all of us that race was an important element in this, and it was important. I think we all understood from our own experience in the organisation, going as far back as the Chokar investigations, that it was important that we should seek to meet the individual needs of a particular family in each case, and we should not make assumptions about what those needs would be. It appeared to us, in this case I think from a very early stage, that it was possible that this family may have distrust of authority, may not believe what the police would say. There was therefore a need for us to ensure that they had confidence that their concerns could be raised with the investigation and that they would be addressed, and that was the Lord Advocate's absolute priority, that Mr. Bayou's family from the beginning should know that they could raise their concerns about the manner in which he had died, and that they could have them considered by the investigation. That could only be done if information was shared with them at a much earlier stage than would normally be the case. And so my understanding of the exceptional nature of it was, in that regard, that was the purpose of it. It was to ensure that his family's needs during the investigation were met.
Do you think this exceptional approach was of benefit to the Crown Office in building a relationship with the family?
That's very difficult for me to answer because I wasn't involved. I've never had a meeting with Mr. Bayou's family. I've never been directly involved. I've never had any discussions or meetings with their solicitor in relation to this. I'm not sure I'm the best person to offer a view as to whether, I think it really has to be Mr. Bayou's family who offer a view as to whether or not that was successful or not, or whether they found that helpful.
Well, we have heard from the family, and we do hope to hear from the Lord Advocate in due course also. We can perhaps ask him.
Yes, I mean, I should be absolutely clear. The Lord Advocate was directly and personally involved in this matter from the very beginning, because he recognised the high-profile nature of the investigation. He recognised the complexity, the need to consider the issues I talked about earlier today, and I think he recognised, as we all did, the need to take appropriate steps to demonstrate to the family that they would be essentially a part of the investigation, and would have an opportunity to air their concerns and be confident that they would be addressed.
I'd like to look at paragraph 38. I think it's quite a lengthy paragraph, if we could move that up. Right. And it says, the traditional Crown approach to engaging with families in death investigations has evolved since the incorporation of the European Convention on Human Rights. This has included engaging with families to ensure that the investigation is Article 2 compliant. The extent of the information provided in this case at an early stage, insofar as I was aware of it, was unusual, and this was a reflection of the high profile and sensitive nature of the investigation and a judgment about what was needed to meet the family's needs. What was the old traditional Crown approach for engaging with families?
I think it was broader than simply engaging with families, but my personal perception is that on joining the organisation in 1994, the independence of our decision making as prosecutors was treated as paramount, which is correct, but it was seen in a very, very narrow way. So, for example, when I joined the organisation, it was explained to me that it was not appropriate to explain to a victim of a crime why there would be no criminal proceedings in the case, and that was regarded as being the right thing to do, and it was about, in my view, independence was confused with distance and separation, and that's really what I'm getting at in relation to the traditional approach. That had implications, I think, in relation to death investigations. So when I started carrying out death investigations from the 1994 onwards, or was involved in them, there was much more limited engagement with the family. It might consist simply of notification that the investigation was underway, and then an offer of a meeting at the end of the investigation, and much more limited active engagement and involvement. So a number of things over those 30 years have caused us to change that approach. The Article 2 considerations are one of those, but there were others.
And Article 2 and perhaps other considerations now permit a more engaged way of the Crown dealing with the family.
Article 2 certainly, as a legal requirement, requires us to do it. I think there probably is still some way for us to go to be as transparent as possible. I think there is still a traditional conservatism about the sharing of information, simply because there is a concern that that may somehow put an investigation at risk. And I think the organisation is still working to, I don't think we've yet reached the point that we will get to in terms of transparency. I think there is still work for us to do on that.
Well, if I may, I'll stop you there, and we can maybe come back to that tomorrow. Would that be possible?
Yes, well, we'll continue with your evidence at 10 o'clock tomorrow morning, Mr. Chairman.